Thank you for logging into our webinar. I'm Dan Wilde, a partner in the business services team at Harding Evans. Harding Evans is one of the largest law firms in Wales with experts specialising in a wide range of commercial legal services. I deal predominantly with employment, shareholder and partnership issues. I'm joined today by my colleague Ben Jenkins and Matt Pamarthan of AMG Wealth Solutions. Matt, tell us about AMG and yourself.
Yeah, thanks, Dan. So my name's Matt. I'm a financial advisor with AMG Wealth Solutions. We're based in Robina in Cardiff. We specialise in pensions, investments, protection and mortgages. The team here of advisors and support staff, I suppose our main role is to help clients understand their finances and also to work with them to achieve their goals and their objectives. A lot of the team have got over 30 years of experience, so we work quite individually with clients, bespoking plans for them to achieve what they want to do in life. Also, I want to just mention the independent status. So if any of our advice or any of our planning leads to a recommendation of any product, then of course, because we're independent, we have no bias, and therefore any recommendation will be the best product available in the marketplace for that client. We work with all sorts of different individuals, couples, families, and businesses. Thanks, Dan.
Thanks, Matt. Ben, can you introduce yourself as well?
I can. I'm the head of the commercial disputes team at Harding Evans. I have significant experience in supporting business owners, so not just on the sharp end when things go wrong and they're embroiled in litigation, but it's also in terms of setting up proper structures to minimise the risk of that litigation in the future. And all too often, I think I speak on behalf of Dan as well, we meet business owners who don't have the proper agreements in place regulating their relationships, whether that's internal or external, and it can lead to businesses being torn apart, unfortunately.
Thanks, Ben. Well, today we're talking about business LPAs as our main theme, and the message is also about proper and effective business continuity planning. COVID-19 has taught us that events can happen that throw us off course. This can happen for other unforeseen reasons such as illness or death, and we're talking today about how businesses can mitigate those risks. This needs to be viewed in the context of there being 5.7 million private sector companies in the UK, an increase of 63% since 2000. SMEs account for 99.4% of the 5.7 million businesses currently operating in the UK today. Relevant to our theme today is that research suggests that over 50% of SME businesses would cease trading in under a year if the owner died, and that nearly half of SME business owners have left no instruction or arrangements about the share of the business. And to sort of make this a bit more interesting today, I've kind of, together with Ben and Matt, drafted a scenario to put to you so we can just help illustrate some of our concerns in this area. So the scenario is that John owns a manufacturing company making decorative panels for garden and indoor use. The company's been trading now for over 20 years. He set up the company when he was made redundant from his previous employment, but he's been very successful and now employs 30 people. He has contracts with companies based both in the UK and across Europe. Much of the time pressure comes in the period March to September each year when orders pick up for garden products. John employs a finance manager, and although there are two other members of staff in his accounts department, he's outsourced his payroll to a third-party company. Because he likes to keep a tight control on expenditure, John is the sole signatory on all payments made out of the company bank account over the value of £100. Only minimum spend can be signed off by his finance manager. These internal constraints are mirrored with the bank mandate. The company has in place the usual insurances for employer and public liability, as well as contents and property cover on their premises. John, due to pressure of work, has not given consideration to other insurances while he's been focused on growing the business. He's also not yet dealt with any other paperwork in relation to the business structure, as he just carries on with the everyday work of the business. He keeps meaning to make a will, which his wife keeps reminding him that they both need to do. John's been feeling a little bit unwell for a few months. He's had niggling stomach pains. He keeps putting off going to the doctor. As many business owners do, they just get on with it. He did eventually see his GP and is now waiting for an appointment to see a specialist. John was worrying about his health, but also about a significant claim that had been issued against the company from a customer alleging the goods that had been supplied and paid for were now defective. The customer is seeking recovery of £50,000 that had been paid for. Unfortunately, John collapsed at home one Sunday afternoon. The payroll was due to follow quite shortly, and one of his major suppliers needs to be paid for raw materials before these are delivered, so that the company can maintain the flow of materials in order to enable its products to be produced and dispatched to various distributors in time for the peak sales period. Ben, Matt, John's just collapsed. He's obviously not going to be able to work. What happens in this situation?
Well, it's a bit of a mess, Dan, that John's in. There's no one there to make decisions for the business, and critically, no one can authorise those payments, whether it be salary payments or to the suppliers, and no one's there also to deal with that claim that's just come in. So in that situation, the business could unravel fairly quickly, unfortunately.
Is there anything that could have been done?
Sensibly, business LPA could have been put in place with a trusted person. In this scenario, the finance manager would make perfect sense to be that person, to take over the business, to make the decisions that need to be made fairly rapidly, to authorise those payments, those crucial payments, to by way of salary and to the critical suppliers, and also to deal with that claim. And not just that, I suppose having that the business LPA in place would have given John peace of mind when he's incapacitated to know that the business will be looked after, so he can focus on getting better and feeling well. And I suppose that peace of mind extends to the finance manager as well, that he knows that the business can continue.
Thanks, Ben. Matt, one of the questions that we've been asked in advance of today's webinar is, why would John need a business lasting power of attorney? Why wouldn't his normal lasting power of attorney suffice? And I suppose part of the same question is, who should you appoint as the business power of attorney?
Yeah, good question there, Dan. So the business sounds as if it's quite specialised. I think the buying side of it, by the sounds of it, obviously John's got huge control over the financials, and the sales side and the operational side is, I don't think it's just anybody who can, as Ben's already mentioned, anyone can step off the street and run the business. I think the business has been running for a number of years. It sounds like it's quite intricate. John has control, but there are bound to be people within the business who actually understand the way things work. And he may have somebody trusted, it might be the finance manager, as Ben mentioned, but I think it's very important that he does have a backup plan. And that backup plan is somebody he knows that he's off work for any sustained period of time, that he can actually turn around to them and they run the business smoothly and ensure that until he comes back to work, that everything is as it was. Now, of course, he might have a personal lasting power of attorney in place now for his personal affairs. But from the case study that's been mentioned, and based upon what his personal affairs might be compared to how the business runs, they look to be very different. So I don't think it's something maybe that his wife could pick up on his behalf. So I do think it's somebody who needs to be within the business, who understands the way that it might work and ensure that the business will run in a very smooth manner until he comes back.
Ben, we've been asked, can anyone object to a power of attorney?
The short answer is yes. So that the donor, or the person appointed, or interested persons who are given notice of that intention could object. So during that registration period, the Office of the Public Guardian would contact the interested people and give them guidance, advice on how they can make objections, and advise them about the basis of those objections, whether it be that the donor or power of attorney's died, or there's bankruptcy involved, or a lack of mental capacity, or simply that the attorney does not want to be appointed. If a family member was really concerned, for example, they could make an application to the court of protection, arguing, whether best interests of the donor wouldn't be looked after, or there's fraud or undue pressure or something of that nature. These arguments, while they're possible, are fairly unusual in a business LPA context.
And can I, if it was me, could I revoke my lasting power of attorney once it's been set up?
Again, Dan, the simple answer to that is yes, but it goes back again to capacity issues. So the donor can, as long as they still have capacity. If they don't, it would mean an application to the court of protection for the revocation of that business LPA.
Matt, if John makes a recovery but can't participate in the business as before, is there anything that John should have put in place?
Yes, there's a couple of things that he could have considered. One is key man insurance, and the other is private medical insurance. So, but maybe before I just run through how those solutions might work, it might be actually just to come back one stage to what's John's position here with regards to the business, and maybe just a bit of context. Why is he running the business? That's probably the question that we need to ask ourselves. There's a lot of hassle and stress, and obviously you've outlined that he's fallen ill. So why is he running the business? Why is he taking on that level of responsibility? But it's probably because what he is thinking of is he can earn more income, he can have control of his business. He probably doesn't like being told what to do as well, and he's probably thinking that the business that he's built up is his pension and also his potential legacy that he can pass on to his family at some point in the future. So taking all that into account, and what you said earlier about 50% of businesses have left no instruction in place. If key people within the business, are unable to work or are off for a sustained period of time, it does make you, consider what would happen in that particular situation. So business protection is an area that can bring some peace of mind, can bring a financial solution to a situation. It can ease the pain of key people or individuals not being around. Although there is a preconception actually when it comes to business protection that it's complex, it's costly, but that doesn't have to be the case. If you're working with professional advisors, then obviously it can be done in quite a smooth manner and a very cost-effective manner as well. I did see a stat last week, Dan, that said that in the UK this year, SMEs will spend something in the region of £6.9 million per day just ensuring their offices and their equipment, which I know it's obviously a requirement and very important, but what about the key people within a business, the people that run the day-to-day, in charge of the buying, in charge of the operations, dealing with the clients, dealing with the financial side? What if they're not there? What happens to the structure of that business, to its goodwill, to the way it operates, its profits, if those key people aren't there? And business protection can actually support that. It can deal with that potential solution to those major issues that would happen for a business. It can be used if key man insurance is put into place for key people within a business, then it can replace profits. It can future-proof the business. It can run the operations on a day-to-day basis. It could support with sales, and it can support recruitment as well. And it's quite simply an insurance policy, Dan, that people use, the business would put into place on the life assured or the critical illness of the key people within the business, and the business would then be the owner of that policy. And any proceeds in a claim would then go into the business to deal with that situation. It is quite individual, and there are calculators that we can use with businesses to understand what their likely shortfalls will be when key people are not there. And again, comes back to whether that's a sole trader, whether it's a partnership, or whether it's a limited company as well. Obviously, in the example, the case study that we're working through, John's situation is that he's obviously fallen ill. and that's obviously going to lead to him being off work for a period of time. And there is one way that potentially you can support that, or what he could do, and that is have a private medical insurance policy. So with a private medical insurance policy for him, he can set it up himself, or he can set it up for the business for all the employees. But that would be able to support him and nurse him through a situation that maybe the NHS can't actually deal with, and maybe speed up his recovery, speed up when he might come back to work, and get the business up and running again.
Ben, John's company's received a claim. Are there any possible concerns around the fact that this claim's been received at a time that John obviously is unable to deal with it?
Yeah, there are. The clock starts ticking as soon as that claim's received, really. So the claim needs to be dealt with. An acknowledgement of service or defence needs to be filed at court within 14 days of service, in default of which a judgment could be registered against the company. So if you do file an acknowledgement of service, that gives you another 14 days. But either way, you've got that 14 days that something needs to happen. And of course, once a judgment has been registered against the company, that has a seriously detrimental impact on its credit rating. There's then the possibility of further enforcement of that judgment. So it could be that bailiffs come round, they try and freeze company bank accounts. There's the option of charging orders against company property, and also the petitioning to wind up of the company. And I've known, for example, people with the benefit of judgments to send bailiffs in during trading hours just to cause maximum embarrassment and to exert as much pressure as possible on debtors to pay. So someone is needed to have that requisite authority to deal with the claim themselves, or instruct solicitors to do that on the company's behalf, and just to try and manage all those issues I described to prevent the business potentially unravelling again.
And we've obviously talked about John being unwell. Would the situation be any different if he were to die?
The situation could be worse if the company's articles of association weren't properly reviewed and adequate. The company would have effectively no director to make decisions on behalf of the company, and it's a statutory requirement that at least one director is in place to do just that. So it would, of course, cause extreme difficulty for the daily running of the company. We still have, of course, the same issues that we've discussed already about ability to pay invoices and staff, and to deal with the claim. Also that the company would be unable to order those products required to deliver on orders, which could lead to valuable loss of business by way of delay of fulfilling orders, for example, and reputational damage. And of course, how long would staff stick around without being paid if payroll is delayed significantly? So John's personal representatives could appoint a director, but that's likely to take months or could mean a costly court application. So for the reasons I've mentioned, really, it's important for PRs to have the power to appoint a new director if needed fairly rapidly. And so it's paramount that the company's articles of association are checked to ensure that can be achieved readily.
Okay, thanks, Ben. Matt, how about that situation from your perspective if John were to die?
Yeah, there's a couple of things that can be considered that John might want to put into place around really the areas of shareholder protection and then business loan protection, just picking up on Ben's point about debtors. Shareholder protection in this particular circumstance may not be appropriate for John because he's 100% owner of the business. And if he was to pass, then of course the proceeds of the business, the shares, would pass on to his family. But that not necessarily might be the case. And going forward, it might be that, of course, there is a director appointed into the business, but shareholder protection might be appropriate. Or what he might want to consider is, of course, the shares being passed to somebody else who might be quite key within the business. So if there was shareholder protection requirements in place, then what really you're talking about is a policy set up on the life assured, on the director, that would be paid out any proceeds on death, written into trust, to another director or to somebody else who could purchase the shares for a fair value within the business. You would need to have something like a cross-option agreement in place already to agree that. So it's just the insurance to support those legal documents that are in place. Policy can be written on an individual basis, and in trust, or it can be written on a joint basis. And again, it just very much depends on the situation, the circumstances of the business, how many shareholders there are, or whether the one shareholder wants to change the actual requirements on his death. But it's definitely worth thinking about and considering. The other thing that they might want to consider is if there's any debts within the business. So this is what's known as business loan protection. And obviously, if a key person who's responsible for the repayment of whatever that debt is not available within the business to drive it forward or even make the repayment, and of course that could lead to the business having some potential issues going forward. The sort of debts we're talking about could be things like commercial loans. They could be, for example, mortgages. They could be venture capital trusts, personal guarantees, or could in fact be directors' loans themselves. And of course, with regards to a director's loan must be repaid on the death of the director into the business. And it might be that the business entity does not have the means to actually repay the debts. So it could be that that actually would cause them an issue. The bank could call in a loan for whatever reason. So now having some sort of protection in place, it would be prudent. So what would it look like? Well, from our perspective, if we were going to give advice, the first thing we would want to have a look at is who's responsible. Is it a jointly liable loan or debt? Is it severally liable? Is it jointly and severally liable? So actually getting to the point of understanding who owns the debt, how that works. Is the debt decreasing, or is it a fixed debt as well? So once you understand all those, you can put some protection in place to ensure that that debt is repaid on the death or the critical illness of the key person within the business.
Should any of those protections be written in trust? This was a question that we were asked by a client in advance of this webinar. Should business insurance protections be written in trust?
Yes and no. So unfortunately, I can't give you a straight answer. It depends on the situation. So we could be potentially dealing with different types of entities. So we could be dealing with a sole trader, we could be dealing with a partnership, we could be dealing with a limited company. So depending on whether it's key man, shareholder, business loan protection, will depend on whether it needs to be written in trust. Of course, we know what a trust can do. It's sensible. It ensures that the wishes are seen through. And generally speaking, when we're talking about shareholder protection on an individual life, yes. When we're talking about key man insurance, there might not be a necessity to do that. And business loan protection, there probably is a necessity to do that. But I wouldn't want to say absolutely that is the case. The other consideration when we're talking about trusts with clients in this situation would be around tax. So, if something's written into trust, is there an issue around pre-owned asset tax as well? So we would want to look at every individual situation and then give advice. And of course, then explain that to the client, and then they can make their decisions on whether they feel their policy or policies need to be written in trust or not.
Thank you, Matt. Those seem really sensible ideas for all businesses to be considering. Ben, do you have any closing thoughts about the issues that we've been discussing today?
Well, yeah, interesting questions we've received from clients and third parties. It's quite revealing, really, what people are interested in and concerned about, particularly at this sort of time. But as I said at the outset, really, we see far too often business owners and shareholders who don't plan for the day that something unfortunate happens, and what could have been really good and profitable business relationships just breaking down, which can be catastrophic for the business and for individuals involved, having to deal with costly legal fees and court applications that could have been avoided. Ultimately everyone wants to concentrate on doing what they enjoy, and I dare say that's not being involved in litigation. They want to crack on with driving their business. So in situations where there's a business owner who hasn't audited their structures and agreements and terms and conditions, etc., and have that continuity plan in place, particularly in the case of illness and incapacitation or even death, then they should do it really. And we have at Harding Evans that sort of audit service that we can discuss those sorts of issues with clients on a bespoke basis and go through it with them to make sure they understand it all clearly.
Okay, thank you for that, Ben. How about you, Matt? Do you have any closing thoughts for today?
Just a couple of things, Dan, actually. Certainly since the lockdown has started, we have actually fielded quite a number of inquiries from clients around business continuity. And I think it's quite clear from your case study and what Ben has had to say that a business LPA and a business protection really do go hand in hand, and I don't see how they can be considered separately. They're an important part of having a sound financial and legal plan to the way that your business would run. Considering how important these businesses are, and obviously owners and directors have had time to think over the last 10 to 12 weeks, is how important their businesses are to them. And the situation, as I mentioned earlier, about owners thinking that their business is their pension and their legacy, is an important one when considering that you need to protect your pension and your legacy. So in a very inexpensive and straightforward manner, peace of mind, your plans secured, delivery of your futures to family can be achieved very, very sensibly and in a very effective manner. So I feel that going forward from here, that we will probably be quite busy with regards to fielding those types of questions and providing advice to clients in this area.
Matt, thanks very much for joining Ben and I today. Well, the subject matter of illness and death doesn't necessarily lend itself to being enjoyable, but we hope you found this webinar useful and informative. If you have any legal questions, please don't hesitate to email either Ben or I, or give us a call. Or if you have any financial advice questions, please do not hesitate to contact Matt, and his email address is matt@amgwealthsolutions.co.uk. Once again, thank you for joining us, and we hope you have a good day.